Good afternoon. This is a arraignment and bail hearing in the matter of State of New Hampshire versus Brittany Barron, at which all parties appear by WebEx. Would counsel for the state identify yourself, please?
Scott Chase for the state, Your Honor.
And would counsel for the defendant identify yourself?
Your Honor, Richard Guerriero for Ms. Barron.
Okay. And Ms. Barron, have you been able to hear everything that I've said and that the attorneys have said so far? Ms. Barron, can you hear me?
Yes, Your Honor.
And were you able to hear the two attorneys just now?
Not completely.
You did not hear the attorneys?
It was a little distorted, but I could hear the voices, yes, Your Honor.
Okay, you can hear me though, right?
Yes, I can, Your Honor.
Okay, let me just have Attorney Chase identify himself again. Let's make sure you can hear him. Attorney Chase?
Scott Chase for the state, Your Honor, and also here is Benjamin Agati for the state. And I think we're actually getting feedback maybe from Attorney Guerriero's connection, but I'm not sure. Or now it's muted.
It's better now. Say your name again and we'll see if Ms. Barron heard that.
Scott Chase for the state of New Hampshire.
Ms. Barron, were you able to hear Attorney Chase just now?
Yes, Your Honor.
Okay, and now Attorney Guerriero, would you identify yourself again?
Yes, Your Honor, Richard Guerriero for Ms. Barron.
And Ms. Barron, were you able to hear your attorney just now?
Yes, I was, Your Honor.
Okay, if at any time during this hearing you can't hear either me or any of the attorneys or anyone else speaking, let me know and we'll do what we can to solve that problem. Attorney Guerriero, does your client waive a reading of the 3 complaints and plead not guilty?
That's correct, Your Honor. I reviewed them with her just before this call.
Okay, very good. I'll note her pleas of not guilty to all 3 charges of falsifying physical evidence. Attorney Chase, what's the state recommending for bail and the reasons for the recommendation?
Your Honor, the state is asking for preventative detention. While the state recognizes that the defendant has been cooperative and has assisted investigators, this case is especially heinous and gruesome. The brutality of the crime, combined with the fact that the defendant's destruction of evidence was in an effort to conceal a capital murder, is especially alarming and concerning for the safety of the general public. Beyond just cleaning up physical evidence in the victim's car, after driving Jonathan's body nearly 200 miles north of the crime scene in Jonathan's own car, deep into the North Woods, the defendant decapitated Jonathan, wrapped his head in a tarp, and placed it in a grave in order to prevent investigators from identifying Jonathan if his body was ever found. The defendant then wrapped Jonathan's body in a tarp and dragged him deeper into the woods, where investigators found him in a shallow brook. This was all with the intent to conceal a capital murder. Had this defendant successfully destroyed that evidence, her husband, the alleged murderer, may very well have evaded detection and or apprehension. And currently, Your Honor, the investigation is ongoing. Evidence is still being collected and processed. If released, there are no guarantees that this defendant will not attempt to further conceal or destroy any other evidence. And for those reasons, Your Honor, and the facts in the affidavit, there is clear and convincing evidence that releasing the defendant will endanger the safety of another person or the public, and accordingly, the state again requests that the court order preventative detention.
Attorney Guerriero?
Yes, Your Honor. You'll forgive me if I am not perfectly organized. I found out about this case at about 1:15 and literally had time to read the affidavit once and to talk to Ms. Barron for about 15 minutes. But I do have quite a bit to say, having just conducted that preliminary inquiry. And I will tell you that although there are very few cases like this at which I start with the weight of the evidence, I think that's where we start on the bail factors here. I think if you look in particular at the affidavit at pages 4 and 5, you will see that in everything that the state alleges that Miss Barron did, she did under duress, and I mean under duress, meaning direct fear for her life after having been beaten, according to the New Hampshire State Police account of this in their interview with her. If you look at page 4, this really started with her being beaten severely. If you look at her face right now, to the extent that you can see it, she still has the bruising on her face and around her eyes, and it's described in the affidavit. Armando beat her severely and threatened her. He put a gun in her mouth, an obvious threat to kill her. He applied enough force to her neck to make it difficult for her to breathe, to the point that she passed out, and chipped her tooth in the incident. She was, to say the least, severely threatened, severely beaten, and placed in fear of her life. The conduct that she is accused of is conduct that she engaged in after having been ordered, according to the affidavit submitted to this court, to engage in that conduct by Armando. I mean, if you look on pages 4 and 5, there's no less than half a dozen times where it refers to her being ordered. And in spite of being ordered under that duress to participate in some respects in this conduct, not willfully, but having to do what she was made to do with fear for her own life, when she was threatened and ordered to harm the victim, she refused 2 times. So to say that she is acting willfully and acted in anything other than under duress, I think is wrong. And the state's own evidence confirms that. That, of course, is from her statement to the police, and I'm sure that's what their response would be. But what they also cannot dispute, and that they would have to testify directly to, is that she then not only provided a statement, but cooperated fully and led to the discovery of evidence, which ended up in Armando being arrested. In plain English, she helped solve this crime, and rather than conceal evidence or falsify evidence, she led the police directly to evidence. She was beyond cooperative. I mean, it's hard to imagine being beaten like that, threatened with your life in this situation, and being fearful and then cooperating with the police. And yet that's what she did by the account of the police. So to say that that the weight of the evidence is significant here is the opposite of what the state has presented. Her injuries were confirmed by a trip to the hospital and by the testimony of the state troopers. When you add the fact that they don't have a lot of weight of evidence regarding these 3 charges, the fact that she's not accused of violence against any person, and that she's cooperated, and then you look at her personal background, to my knowledge, she has no prior criminal record. She's been a resident of New Hampshire for the past 6 years. She's been living in Jaffrey and employed. Our proposal would be that she be released on electronic monitoring and continue to live at the same address in Jaffrey at 63 Main Street. We would agree to any reasonable conditions of that release. I would note that she has a minor child that is obviously involved in this case. That child needs her mother. She is a 9-year-old daughter. And there's simply not a good reason to detain her here when you think about the factors that we look at. Is she going to show up for court? Obviously, and electronic monitoring will ensure that she shows up and that we know where she is. Is she a threat to the community? There's no evidence whatsoever that she's a threat to the community. The evidence is that she's a victim who cooperated with the police. So our position is that she should be released on personal recognizance bail with a special condition of electronic monitoring under the supervision of the Cheshire County House of Corrections.
Okay, thank you. Attorney Chase, your reply?
Yes, Your Honor. There's no doubt, and the state does not deny that there is substantial evidence that the defendant was assaulted by her husband, Armando. However, while there are factors surrounding her crime that may have impacted her decision to commit those crimes, those factors were taken into consideration when the state evaluated what charges to seek, and more importantly, are factors that are for a jury to consider in determining her guilt, not in determining her threat to the community. For example, defense counsel said that there was no evidence of violence. There was evidence that she used a knife from a machete to cut the victim's wrists or hands after he was kidnapped or forced into the car at gunpoint. Again, those charges weren't brought out of consideration for the facts and circumstances surrounding the incident. However, discount the fact that the defendant drove nearly 200 miles in a separate vehicle with a cell phone on her person in transporting the body for 3.5 hours approximately, Your Honor, with multiple opportunities anywhere in between Ringe and the scene of her crimes, demonstrates that she had multiple opportunities to avoid committing the crimes that she is currently charged with. Another example of that is the steering wheel itself. Her cleaning that steering wheel was after Armando, as Your Honor can see in the affidavit, had gone to destroy other evidence. Beyond that, Your Honor, she did cooperate. She cooperated after she was caught. She had multiple opportunities prior to being caught by New Hampshire Fish and Game to seek help, to avoid, regardless of, in addition to the 200 miles that she drove and had the opportunity to prevent herself from feeling like she needed to commit any of the crimes. The incident of the hunters, 3 different times or at least twice where she had opportunities with those hunters to say, I need help. Armando wasn't there. It was her and the victim's body. And she did nothing to alert the hunters or any authorities that she needed help. But instead, she continued to participate in an effort to conceal evidence, to prevent the discovery of that evidence. And again, we're talking about in a crime of capital murder. In a heinous crime, she was participating in hiding, destroying, or concealing evidence that could have prevented the detention from an alleged murderer, which is the most dangerous situation that could have happened, is if he failed to be apprehended or charged with these crimes because there was no evidence. So the fact that the case is ongoing, the fact that evidence is continuing to be discovered and to be processed is support for the clear and convincing evidence that she is a danger to the public.
Attorney Guerrero, anything further?
Yes, Your Honor. I just want to point out that not only had she been threatened with a gun in her mouth and beaten severely and ordered by Armando to participate in this conduct of destroying evidence, concealing evidence, depending on what aspect of it you're looking at. Armando, in fact, had access to her daughter and later did have custody of their daughter. So beyond fearing for her own life, even after she was left alone, she had no idea what else he was going to go do. And I would point out that there's no allegation of any violence that she engaged in that was not under the direct duress. And I mean direct duress in the sense of being threatened with death after having been beaten, direct duress from Armando. I simply don't see how the state can say that they've carried their burden by clear and convincing evidence or demonstrated that she's a danger to the community. Electronic monitoring will be more than sufficient to ensure that the jail knows where she is. They protected the community. There's no evidence of any other violence of any other kind in her life. There's no evidence of other instability in the form of drug use or other criminal record. There's no evidence of any failure to appear. There's simply no reason to deprive this woman, who is presumed to be innocent, of her freedom at this point.
Your Honor, if I may make one more point.
You may.
Your Honor, as you can see in the affidavit, when Armando, the individual who defense counsel is claiming was directing all of the defendant in this case's actions, when he left her in the woods with the body, with the evidence, he left her with 2 firearms. When law enforcement found her, she had a loaded 9mm handgun on her person. She did not make any effort to defend herself or the evidence of the crime. She was armed with 2 firearms. She had complete opportunity to notify others, to seek help, to avoid Armando coming into contact with her children, both when she was driving the 200 miles up north, she could have called authorities. She could have pulled into authorities. She could have flagged somebody down on the road. There's numerous opportunities for her to have ensured that Armando was not going to have contact with her children. Beyond that, yet again, when she had the opportunity, when she was in the woods, she had firearms to defend herself. She took no action to defend herself, to alert authorities, or to help the situation at all. So again, based upon all of that and the totality of the circumstances, by clear and convincing evidence, she is a threat to the public if she is released, Your Honor.
Your Honor, can I just make one new point? I don't want to take up your time here, but there's not an obligation to report a crime, and there's certainly not an obligation to report it when you've been threatened with death and beaten. She had she's just simply not obligated. I mean, I know the state wishes she had done that, but she was not obligated to do that, and frankly, her fear is totally understandable.
Okay, well, having considered the allegations in the probable cause affidavit, each party's arguments and offers of proof, and all relevant circumstances under the bail statute, at least at this time, I do agree with the state that it is established by clear and convincing evidence that the defendant's release will endanger the safety of the public, so I am going to grant the request for preventative detention at this time. Anything further, counsel?
State, Your Honor.
Not at this time, Your Honor.
Okay, very good. Then this matter is concluded.
Thank you, Your Honor.